Wange not an institution?
It's an institution, but not an institution of government.
But is it not an institution where revenue, state revenue has been put in?
Yes, it may be, but it's not an
No, you cannot say maybe, Attorney General. Is Wange not an institution where state money has gone in? You cannot speak with a folk tongue. 1 minute you're saying government did the Reconstruction Act because it is state indebted and insolvent. This is your compelling reason. And now you want to run away from it. What was the compelling reason, Attorney General, for you to do the Reconstruction Act? Maybe let's go back.
No, the fact is, Chairman, that an institution may be indebted to government doesn't make it an agent of government.
Can you answer the question? What was the motivation of government to reconstruct Wange?
As I explained, the two requirements are outlined in Section 4 of the Reconstruction.
So you are not responding.
And that is the...
Attorney General, let's go together. Let's not, we are very clear. We have a role to play. And this is the Constitution which binds all of us. If members are following this, you are very clear in why government got involved. It was a state-indebted, insolvent company. That was the compelling reason. State-indebted, insolvent company. Then we come to 299, which talks about parliamentary oversight over state revenue. And revenue at any institution. Because you want to hide behind the fact that all agencies of government. But this does not, it talks about all agencies of government, and it also talks about institutions which are not run by government, but government has a stake through state revenue. And you're not responding to that.
I'm not sure how the Chairman wants me to respond. I think I'm trying to make myself clear that as far as I am concerned, the agencies which are subject to parliamentary oversight are agencies of government. And there has to be very clear factors indicating why one would say that they're agencies of government. And in the case of companies which are put under reconstruction orders, the fact that they are indebted to the state does not make them necessarily government agencies. Government has to go further and ensure that it controls them for them to be government agencies. And then they are subject to parliamentary oversight.
But you're then contradicting yourself. Because government does not control Wange.
Yes.
It does not control Wange, and you're saying yes.
Yes.
So then, why did it go for Wange?
No, the Reconstruction Act applies across the board. It applies to entities that are not controlled by government as well.
But then it also talks about institutions. So what is an institution?
Yes, institutions of government.
No, it does not say institutions of government.
It says institutions and agencies of government.
No, it talks about all commissions and institutions and agencies.
Of government.
But commissions are not state-owned.
Well, as long as they're commissions, commissions are incorporated by statute.
So then, if you then say, let's go further. Is there follow-up on this matter?
Yes.
But Honorable
Chair, the very fact that the Attorney General is a lawyer of government, the very fact that Parliament is an arm of government, how does the Attorney General excuse us in a setup where government is involved and Parliament is an arm of government? The government has got three arms: the executive, the judiciary, and the legislature. And the Attorney General is a lawyer of government. This is why he has come here and is obliged to be here. Because he's a lawyer, he's our lawyer. He's a lawyer, he advises government. This is why laws pass through the Attorney General for advice before they even come to Parliament. And this is why the minister had to engage the lawyer of government. Because Wange, he has got interests of government. And under section 299, Parliament has the right to oversee expenditure by the state. And the state is comprised of the three arms which I have alluded to, where Parliament is part of. Why then is the lawyer of government comfortable by working for government and not comfortable for Parliament to interact with the administrator working where there is an interest of government?
General, are you aware that the one year debt came through Papa Parliament?
It may have been authorized by government. I don't know, I haven't been given those facts. But Parliament, and certainly this committee, has every right to follow the debt through the Minister of Justice and through the Minister of Mines and call for explanations as to what is happening.
Thank you. Let's hold it there. The administrator is working on behalf of the Minister of Justice and Minister of Mines. So why are you not comfortable in allowing us to have access to the administrator?
Well, I didn't say you cannot have access to the administrator. All I am saying is that Wange as an institution is not a government-controlled entity or institution.
So
And that parliamentary oversight.
Attorney General, by virtue of invoking the Reconstruction Act, Wange now directly falls under the Minister of Justice. So therefore, where the minister is, Parliament goes.
Yes, that's why I'm saying this committee has every right to call the Minister of Mines, the Minister of Justice, to come and explain to this committee what is happening.
But you see, yes, sir.
Attorney General, so is it, can you put it on record that so you came all the way from your office to tell Parliament that hands off one? Is it what you came all the way from?
No.
What is your advice to us in short?
Well, that's why I said I'm not giving advice to Parliament or to this committee. This committee is entitled to its own legal advice. Just to clarify.
This committee, sorry, as to what is your advice to us as a committee in short?
I think
I think it's beyond my mandate to give you advice.
No, I think to just put it in a way which relates to what we're talking about, is that we have the issue of the administrator who clearly has refused to be accountable. Okay. And the Reconstruction Act empowers the administrator. So it is the powers of the administrator. How far do they go? Is the law unto himself? He is appointed by the Minister of Justice. And by virtue of being appointed by the Minister of Justice, which is also another, that's another arm of the state which is government, which is accountable to the Parliament. What do you make of that? Because my next question is that, okay, who does the administrator then account to?
The administrator, in terms of the Act, accounts to the Minister of Justice who appointed. So, but in terms of the Act, he's not accountable to anyone else except the Minister.
But who is the Minister accountable to?
To Parliament. Right? Yes. But you see, you cannot do it by extension. To say because he's appointed by the Minister, therefore he's also accountable to Parliament.
But you're not understanding, Chief Justice. To be honest with you, sorry, Attorney General, I think we cannot play these games. There's certainly something which is a very clear. This is state revenue, first of all. We must agree. This is state revenue. And when it's state revenue, Parliament is an oversight over state revenue. And it is the same thing that no one, probably except the president, cannot be summoned by Parliament. If Parliament believes there's an interest, equally, and we now go to standing rule order, because I think we've done this one, let's go to the green book, which compels us to invite anybody who we think has something to say to the aspect of the inquiry. The inquiry is not only limited to government enterprises. Government has other players that engages. And the inquiry goes as far as also inviting those players. This is about national interest, this is about accountability. So to us, we are really not understanding government's position, because if there's anything, it actually gives credence to the fact that this Reconstruction Act was not done in a manner which even the Attorney General understands. Because they're failing to really explain it.
Does this mean, Honorable Chair, that if the minister gives instruction to the administrator, he can actually hide behind the administrator, because we cannot interrogate the administrator because he's not accountable to us?
Can I also follow up on that?
Yes, Honorable.
Yes, Attorney General, if you believe there's a lacuna in the law, what would you have it read for you to really say now Parliament or this committee has power to summon whoever it requires, especially as it relates to this investigation? What is it that you think would be required to be included in the Constitution according to what you believe, so that it can either cover that lacuna, to read the way you want it to read, for this committee to have the power you believe it has, which is not supported in the law? What would you want?
I think that's the question as we wind up. And I think just note it, that if there is a lacuna, but I don't think there is a lacuna, because this is state level, simple term, state level, and state revenue must be accounted for through Parliament oversight. And this is where you are not being clear to us, Attorney General, that what was the compelling reasons for the Reconstruction Act was because government has a stake in one. And it hasn't really got a majority stake, but you still went on to reconstruct it. Okay. And reconstruct it, it was because of the money. State indebtedness. It doesn't even talk about it controlling a state, but because government is owed money by Wangi, you felt that it was insolvent. And then you went to then reconstruct. Because the other question is, how many other companies are under that? I mean, we have to look at government expenditure in terms of all the state enterprises. There are shareholders who are not government, and government is not the sole shareholder, and you did not respond to that. And you cannot get away with it. And first of all, we must agree, step by step, does Wange owe government money?
Yes, it does. Certainly, otherwise we would not have been put under an order of reconstruction.
And you believe that is state revenue?
Yes.
So 299 talks about state revenue. And yes. Why are you not aligning yourself to 299?
Well, maybe let me try to explain myself in another way, Mr. Chairman. Parliament cannot exercise over a company like Wange any power that it would not otherwise have if it's not under an order of reconstruction, because it's a privately controlled company. It's got its shareholders and other people. So, Parliament, if there was no order of reconstruction, Parliament cannot itself exercise oversight over one.
No, we do. We do. Where there is money, even if it's 1 cent and it's from its taxpayers, we move in. It must be accounted for.
Well, if Parliament can trace that authority and power to the Constitution, then it's in order.
But because you're now confusing the whole thing, Attorney General. 1 minute you're saying Parliament has no power to trace Wange, the next minute government can take over Wange.
No, what I'm saying is the order of reconstruction itself does not make Wange an institution of government. And Parliament only exercises oversight over institutions.
But that's not, I think you're missing the point. World is not an institution of government. Government has invested in Wange.
Yes.
It is the revenue. And then don't take us round and round. We are following the money.
Yes, but the
Honourable
revenue.
members, the issue is the revenue. The money government is putting into Wange, and that's our interest.
Yes, I completely understand that. That is why the minister is following up on it. And that is why he issued the order. The minister is following that money in a privately controlled company.
Honorable Chair. For Wange, even without invoking the Reconstruction Act, even before that, Parliament would have the right and mandate to follow public funds. Why? Because Wange as an entity has received advance payment from ZPC. That's public funds, and we have a right to follow those funds, even if it were a cent. And I'm coming back to this. I'm not sure if, before advising the minister to invoke the Reconstruction Act, you really were furnished with total and complete documents to enable you to consider whether it's viable to put this company under reconstruction. Because from what you are saying, I see clearly that you are not aware that ZPC was advancing money to Wange, notwithstanding the fact that there are other shareholders. That's government money on its own.
Well, I was aware that Wange is indebted to government and other state institutions to an amount of approximately $118 million. That I was aware.
And are you aware that debt was converted into a loan that is payable in 15 years' time?
Well, I'm aware that it was converted into debentures. And debentures are just loans.
Payable in 15 years' time.
Yes, under a scheme of arrangement. And I understand that the scheme of arrangement was not followed through. And that was why the minister then deemed it fit that action must be taken, or else Wange should be placed under judicial management in terms of the company's
Did
act.
you consult other players? And because what I would want to also understand from you is that where does it leave Wange? Is the private company now under the reconstruction? Because there are certain shareholders who have their rights. And their rights in terms of the Companies Act. Well, can you talk to us about that?
Yes, Wange is still a private company. We still got those shareholders. Nothing has changed except that the authority and powers of the shareholders are now vested in the administrator for the time being. That is what the Act seeks to achieve. But they are still there. It is still a private company.
But the shareholders, honestly, if you really look at it, Zimbabwe is open for business. That's why we need clarity on this. That anybody who registers a company in this country becomes a shareholder. They can just wake up tomorrow and the company is under reconstruction. And that's what we are saying.
This is an act which is in our statute books and which is available to any investor to be to peruse or to be advised of, and investors make their investment subject to the laws of the country.
Okay, just before, but Section 71 talks about property rights. Property rights, 71, and people with property rights. Have you not violated this supreme section of the Constitution?
No, Mr. Chairman, no person has been divested of his property by virtue of the order of reconstruction.
Attorney General, if you look at precedents and previous conduct of government in respect to companies that have been placed under reconstruction, the culture or practice is that immediately with absolutely no explanation, those companies end up belonging to government. I want to give you a practical example. When we were in Bunawa a week ago, the Minister of Finance listed about 17 companies that were subject to privatization. And amongst those were 2 companies that I clearly know belong to SMM, and these are up for privatization under ZMDC. So for me as a member of parliament, the assumption is once under reconstruction, a company therefore belongs to government at the end of the day, and government can do as it pleases. But attached to this, my commentary, and perhaps part for the last answer that will attach to Nduna's question, my question to you is, you advise the minister, do you really think this is good law, particularly in respect to our going mantra that Zimbabwe is open for business? And should this piece of legislation really exist outside the ambit of the Companies Act? You may want to save this one for the end.
I think Honorable Nduna had this question, you might as well also respond.
Can I just maybe add on to that, Honorable Chair? Honorable Chair, I also want the Attorney General to tell us what he reads, Section 117 to Section 119 of the Constitution, that gives us our mandate, that is the oversight, the legislative and the representative role. How he interprets that to mean in terms of our interrogation in our quest to carry out our mandate as parliamentarians, not only as a committee of parliament, but as parliamentarians, our 3 roles in one. How you see us fitting into those 3 roles without interrogating the manner in which other institutions that are outside government institutions carry out their mandate.
I'm not too sure I get your question. Please, do you
Okay, we have 3 roles. The legislative, the oversight to interrogate the manner the executive carries out its mandate, and the representative role from where we come from, of over 50,000 people on each member of parliament, the 210 of us, plus the 60 representatives, the proportional representatives. What do you read that to mean, the 3 roles in one, as it relates to the way we carry out our mandate? Because I see you restricting Parliament to carrying out oversight only on government-related institutions. But we are not only on that line of thinking or on that line of mandate. We have 3 roles in one. I ask for you to define what it means as it relates to those 3 roles.
Perhaps I'll reiterate what I said earlier, that Parliament can only carry out its oversight or in terms of the mandate is granted in the Constitution. And you asked earlier whether there is a lacuna in the Constitution which then stops Parliament pursuing wherever government revenue is gone, notwithstanding that is not a government-controlled entity. And my response to that would be that in Section 299 of the Constitution, an additional power would have to be inserted to give Parliament the right to follow government revenues wherever they've been invested or expended, notwithstanding that the institution or agency is not controlled by government. That would have to be a specific power to be inserted into Section 299 of the Constitution. That is my view. I'm not advising Parliament, neither at this stage am I even advising the executive on it.
But Attorney General, you're the same Attorney General who recommends the President to appoint 9 ministers in cabinet instead of 5.
I did not advise him.
So then how can the President make such a decision?
No, I only advise where my advice is sought.
No, but you're the Attorney General,
yes.
And you're there to advise the President on the legal issues. They think President made a boom by appointing 9 ministers in terms of 5. And where were you? Where were you in terms of giving that legal advice?
Mr. Chairman, when a lawyer advises a client, it's up to the client to do what they want.
So you're telling me that the President disregarded your advice?
I'm not speaking for him. You may ask the President.
Honorable Mure, and then Honorable Matamala.
Okay, thank you very much, Mr. Chairman. I just want to pose Mr. Attorney General, are you aware of the activities which is being done in Wange? I mean, things like rampant corruption and looting which is going on in Wange. Before I proceed.
No, I am not.
You are not.
I've been given, maybe if I may just explain further, I've been given certain information which is to the effect that there's been mismanagement at Wange, and that therefore an inquiry is necessary, and that is why the order of reconstruction was then passed on Wange. That enables a proper investigation to be carried out through an administrator who will then report back to the Minister of Justice with these conclusions.
Okay, Honorable Matamala.
Thank you, Chair. Subsection 299, at every level, Parliament is not going as long as marriage to come here. Immediately, also, when I'm planning to not visa secretly, or most like me checking as we move constitution, or also leadership. And rather kuna kuga zofikiza la mumuna ani maiti sabo like this iwo umtimo mama soberenga maberenga sanana matipa masiba profa matutolera kuti gaita kuti tirambe kumilirire muno sokuzokanaka nalo ndemo milira urende na president vasasekwa kana kuti vasashoka kana kuti nyika isaparara kana makuti imweni pana mutemo mutemo uyu wamazikoro kuti isusu hatina simba wakanyorwa nevanhu vese sokunyerwa kwaitwa neconstitution ichitendera nyika yese. I doubt very much because I think wakaiswa nevanhu vekuru vanga vakuziva kuti tinoziva kana zvakudai tinokwasavhara takanai nokuti panapa hapasina chokwadi because mutemo uri kutaura zviri pachena unokuti pasimba taita kuita anovharwa panze taita mastupid nyika yese yazvoona touya pana takudzwa kuti makaendeko kubairo but yeti mutemo ndiwakatengesaiko makuuta husimo saka izvozvo imimi kana muri society imi maiona mutemo wakadai uyu makausiya siuchidzidza kutiramba wakadai munakuuka tsimo usataita kuwangu tange mabhisa apa zvinokubharika taii ukaenda ikoko zvinopedza zvadzora zvino zvaoisa mari yegavhumenti akakwira ndege tikaenda kuti kati mari yehurumende yekoparara zvakangofanana nezvakaifambireko zvaiparara saka imimi wai makauregera mutemo uyu uripo pasaidi wakanyarara uri saireni nhasi unomakukuti
mhinduro yangu ndingangoti inini attorney general handisi rindinoita mutemo.
But you are sounding to be part of the problem.
No, honorable members, I think that's something that we can deliberate amongst ourselves. We will deliberate with that. Honorable Choma, we need to conclude.
Okay, thank you, Chair. You mentioned that, I just want you to make clarity. There was a court order that gave birth to the scheme of arrangement. and you put in the Reconstruction Act. There I wanted clarification which the act supersedes the court order. Number two, you mentioned that one of the compelling pushes that made you go and to implement the Reconstruction Act, that there was rampant mismanagement, and hence the reconstruction will give you ample time to get into an inquiry. Are you aware that there was a forensic audit ongoing that had been instituted by the board of directors there, and the report was due to come out in January?
Attorney General, just on supplementary, are you aware that the scheme of arrangement was before the High Court? And can the Reconstruction Act override the High Court?
A scheme of arrangement is an order which is obtained by parties who approach the High Court and say, can you please give us this order? That is the order they obtain. And that order is granted on the understanding that the parties will abide by it, particularly the debtor. If the debtor fails to abide by the scheme of arrangement, then depending on the terms of the order may cease to be in existence because it's been breached. So the issue of whether or not the Reconstruction Act supersedes it is really neither here nor there. The thing is that the Reconstruction Act is an act of Parliament, and it sets out what the law is. If a company is indebted to the state and it's insolvent, then it can be placed under a reconstruction order, regardless of any other factors.
Okay, I think we have Honorable Chairman Honorable Gebus, okay, Honorable Chombo, President.
Well, it wasn't answered. Were you aware that there was a forensic audit going on which was supposed to give a report back in January?
Yes, from the papers I got, there was mention of a forensic audit which was going on, but the forensic audit itself cannot stop, like I have said, an act of Parliament being implemented.
Mr. Chairman, is the Attorney General confirming that he received confirmation from the debtor that there was a breach in terms of the High Court order for the scheme of arrangements?
No, I did not receive any confirmation from anybody. I acted on the information that was provided to my office by the Minister of Justice, which is obtained from the Minister of Mines. That is the information I acted.
But you know, Attorney General, what the member is trying to get to is that you're supposed to consult us so that you get this information. And while the Reconstruction Act also gives the power to the minister to reconstruct and then us later, that whole process has not been done of finding out from the stakeholders, from the shareholders, what is it. And you are getting information without also having to get more information from other stakeholders. What are you doing to ensure that you think fulfill that?
The information I got was that it was urgent to place the company under an order of reconstruction, and that it was also urgent to do so before other creditors applied to the High Court to place the company under judicial management. So on the strength of that, I did advise that the company could be placed under an order of reconstruction, and that any consultations which were necessary under the Act would be done afterwards.
When one of the board members, Mr. Tome, I hope he's here, was under oath, he said while following up on the process of on trying to inquire the paperwork which had been sent to the Attorney General, he found out that the reconstruction order had been issued while there was no paperwork at the Attorney General's office. So now the point of order arising that is that there are two conflicting statements of the same, intending to have the same impact, but made under oath. We get the correct position.
I think the information that was being referred to, which was not available, is the only information that may be collected after the publication of a order of reconstruction. And that information is the application which will have been filed with the High Court for purposes of confirming the order of reconstruction. That is the application that was not there, and even today is not there, but we are hoping to file that application this week, because the Act gives the Minister 30 days from the date of publication of the order of reconstruction to file that application.
Mr. Thomas is in the House, Honorable Chair, can you clarify? You can't assume.
May take off.
No, it was Mr. Tome, and where is Mr. Tome? I saw him. Come here. There. No, it was Mr. Tome. But if I'm wrong, you may want to say I'm not correct. Mr. Tome.
I, Edward Thomas, swear that the evidence that I'll give is the truth, the whole truth, and nothing else but the truth. So help me God. Thank you very much, Honorable, for your comments. It was actually the chair, then I came in afterwards. But oh, okay. But the important thing is that, yes, it is very correct what you are putting across, Honorable Member, to the House. That at the time of the publication of the Gazette for the reconstruction of Wange, Parliamentary Company Limited, there is no founding documents on record. And like the Attorney General is saying today, there's still no founding documents. Maybe he had more information which he could not make public or make available ordinarily to the shareholders and the directors of the company at that material time. I thank you.
So, Attorney General, where are they found in documents?
Yes, those are the ones that I may have explained, Honorable Chairman, that the Minister has 30 days within which to file that application, and that application will be filed during the course of this week.
So we,
on what basis, Mr. Tome, your understanding of the founding document, what are their purposes?
Thank you, Honorable Member, Chair. The only thing, if maybe I was in the shoes of the Attorney General, is that I will have to act on written records which cannot be altered tomorrow to suit circumstances. So it is important that before you would have made an order, you would have founding documents on record, so that even today as is challenged, these things can be produced, whether by shareholders or by any other stakeholder. That's the whole importance. Even those that may want to support or challenge the reconstruction order of Wange would then have something on record to then challenge that particular course of action.
Sorry, Chair, I mean not to have a one-on-one with the government. Are the founding documents for the purposes of convincing the Attorney General to make a decision either to advise the Minister to place the company on the Reconstruction Act or not? Did he
Yes.
need the founding documents for him to make that decision?
Yes, ordinarily you would need that, but not just for him. It's also for shareholders and other key stakeholders, like us, the directors, to understand the basis of that particular course of action. And even yourself as Parliament, anybody, because there must be public documents.
I have a follow-up, Mr. Chairman. The quick one for the Attorney General would, of course, be how then did you make this decision? But given what the committee is learning now from the board member, is the Attorney General ready by any means to hear the other side before going to court in a few days' time. The other side being the other shareholders. I know you have indicated that you were told the other shareholders were ready to make an application for judicial management. But given the circumstances, are you ready now to hear the other side before approaching court?
Honorable Chairman, I can only advise the Minister to act in terms of the provisions of the Reconstruction Act. And if you have regard to the notice which was published in the Government Gazette Extraordinary on 26 October, General Notice 938 of 2018, it is headed Notice of Intention for Application of Confirmation of Reconstruction Order, Wange Colliery Company Limited. This is a notice to the shareholders, to the creditors, and to the board to say that that application will be collected at my offices. And I've explained that that is the application that sets out the whole basis upon which the reconstruction order has been made by the minister. And the purpose of the application is now to get a court to judicially confirm whether it's appropriate for the order to remain in force or the order should not remain in force. And that is the application that contains all the details which the creditors, shareholders, and board members are supposed to collect and have access to. And that is the one I've said will be available during the course of this week, because the Act itself grants the minister 30 days within which to file it. That is why it has not been available from 26 October.
Mr. Nasir, you taken off?
Yes.
Can you respond to those this company's said?
Thank you. I think
maybe if you think stand up, please, so that
yes, I think fundamentally the point is that if you read the Gazette itself, it is an intention that the Attorney General says. But the application itself that the Attorney General is making reference to say it will be filed sometime this week is founded on what are referred to as the supporting document, right? So that application ordinarily is being formulated on supporting document. The question here is that we are referring to those supporting documents as not being there as of the 26th of October 2018 today. So that is the issue. So if you read that Gazette, it says the minister further gives notice that the documentation in support of the application, it's not talking about the application, the documentation in support of that application. So in essence, these documents are seated somewhere, because they are the documents which then formulates the application. So we are saying for anyone to then make a representation or oppose or make any position as far as that application is concerned, he must have reference to the supporting document. Otherwise, that application would be unaware of how it's then found. So the Gazette itself makes reference to there being documents in support of the application. The application may not have been made fine, but the documentation in support of that application are here made to say they may be collected by any party interested in the application from the Attorney General's office. It's very clear. On the day of application, that is what the Gazette is saying. So these documents are not there. So whoever is interested has to make a response to the application, but we're not talking about the application, we're talking about the support documents which form the basis of the application. That is what the director was referring to say, look, in as much as we want to look at the circumstances upon which the order was or the notice itself was then founded, the very Gazette is making reference to there being support documentation which will form the basis of the application. So, in essence, these are the documents which, at the date of publication of the Gazette Chair, were made to be said to be available. That's why we went there to try and understand the circumstances. But today we are still saying that we don't have the support documents. So that's where the clarity is. We're not talking about the application, we're talking about the support documentation which forms the basis of the application.
I think it's very clear, because if they have to object the statement, they object based on the supporting documents. So right now, what is it that's there for them to object to? Attorney General, where are the supporting documents? Which should be readily available the moment you guys it.
If you read the Act carefully, this is an issue of interpretation. The whole purpose of making those documents available is to enable a creditor, a shareholder, or a director to oppose the application. That is the whole purpose. And making those documents available without the application does not serve any purpose. The Act is very clear that the minister has to give 14 days notice to the creditors, shareholders, and members of the board within which to oppose the application. And the application is the one that contains all those supporting documents. Because without the application, there's nothing for them to oppose. You have to be able to oppose the application that will be placed before a judge.
So AG, have you sent that notice, that 14 days?
No. When the application, the whole purpose of the notice is to avoid physical service of the application upon each creditor, each shareholder, and each board member. So the purpose of the notice in terms of the Act is to say, because of the publication, we consider that you will have been served and you'll be given 14 days within which to oppose. That is what the Act says. So now, we prepare the application, we file it, and then we keep it at our offices for them to come and collect so that they're in a position to oppose the application. That is the whole purpose of those.
That's what I'm saying, 14 days.
Yes. It hasn't started to run until they collect.
Days. It's within 30 days, right?
Yes, the filing, yes.
But this reconstruction happened in 26 October.
Yes.
And now we are 20 November. So the 14 days you're talking about is when?
No, the 30 days within which to file starts running from 26 October.
Yes.
But on the date on which a member collects the application, there are 14 days within which to oppose.
This is what I'm saying. Has the notice gone through so that they are able to oppose?
No, that's the one I said we'll be filing this week.
But we are really out of time. I mean, let's be legal. 14 days, honorable members, you are listening to it. Okay, in terms of the law. You're also breaking the law, Attorney General. 14 days. When is 14 days, Attorney General? 14 days was when? Let's now count the days, the thing legal days. Help us. 26. To remove the weekends and everything, because there are days where the court doesn't operate. So help us when the 14 days is. When is the 14 days?
The 14 days only runs. This is the notice to the creditors under the application. The application is filed within 30 days of the publication of the order.
After the application has been filed, but the aspect of the founding, the supporting documents, are people not entitled to those?
Yes, they're entitled to them together with the application so that they can oppose. Yeah, that particular application, it will have a case number. So as soon as they collect it, the application will explain why the interpretation given by the minister to those documents, which otherwise would not be available to a board member or a creditor in the absence of the actual application. So, if, for instance, it's their management accounts which the minister is relied on, the minister has to explain in his application what interpretation he has put on those management accounts for him to arrive at a conclusion that an order of reconstruction is merited. So, if the application is not there and there's only the management account, it won't be able to tell much to the board member or to a creditor because they probably already have them in their possession anyway. But it's the interpretation which the minister is now putting on it to justify the imposition of the order that is important for them to be able to mount an opposition to the application. That is why that supporting documentation has to be accompanied by the application itself, which the minister will have placed before a judge in asking for confirmation.
Mr. Machaya, that's an order. I don't want to be a judge, but I think from a legal position, that's the legal position is given. Vis-a-vis your point of saying that the supporting documents must be there.
I think the point remains that if you look at it, unless maybe the Attorney General may consent, are we going to see another notice? For which I take this to be the notice. This is the notice. Unless we're going to see another notice of the 14-day period, because this gazette clearly says anyone who wants to deal with this particular aspect may collect. It doesn't say at a certain date. It clearly says may collect. Unless we're going to see another notice, which I doubt because this talks to.
So there,
this is the notice.
General says may collect.
Yes.
What is your response to that?
If there is any shareholder or board member or creditor who is aggrieved perhaps that the minister has not followed the time period stipulated in the Act, then they are free, because the matter will be judicially decided after we file the application. If we have not followed the provisions of the Act to the letter, the judge will not confirm the order.
But
the order will fall away.
What we are asking is that the Act says may collect. Is there anything to collect? Because you seem to be giving us, this is the reason why we brought in Mr. Machaya, because we are not lawyers and you are playing with the legal jargon. That's why I decided to bring in Mr. Machaya so that he is reading to the Act and you are not reading to anything. It would be nice for you to be a lawyer to be reading. He is reading to the Act. So what is it that does counter that what he's saying in terms of the law? Because it's now hearsay. Because we don't know, because Mr. Machaya is referring to the Act, honorable members. That the Act says they must be there and anybody can get. He's not denying what the Act says. If there's anything, it's just saying more and more the application. Yet before we even go to the application, the Act says that information must be available. Any aggrieved party must have access to it. And the question is that information there?
I thought I'd already responded to that, Mr. Chairman. That information has to be accompanied by the application. That's the whole purpose of the notice.
But the Act doesn't say that, what it is written.
I'm not sure what he's been reading in the Act.
But the thing about it, we don't know what you're also reading from.
Yes, that's why I said at the end of the day,
you are constantly using your brain, okay, and being a lawyer, but he is reading to the Act, and the law is about reading to a law to Act.
I'm also reading the provisions of the same Act.
Which one? Can you tell us which provisions?
The same Act, the Reconstruction Act.
Let's go legal. Which one? Provisions of the Act.
Sorry. Section 8.
What does
the Reconstruction Act.
What does it read?
It's a long section. Subsection 1, I just sorry?
Yes, read it. We're here to listen.
No later than 30 days or such longer period as a judge referred to in this section may allow, after a reconstruction order is issued under Section 4, the minister shall, by application made by the minister or on his or her behalf, seek an order confirming the reconstruction order from a judge in chambers on not less than 14 days written notice, and then in brackets, accompanied by the documentation in support of the application referred to in subsection 2A and B to the shareholders, creditors, and former members of the board of the company under reconstruction.
Mr. Machaya, can you read your Act?
I think the section is pretty clear. He has read it. The Attorney General has read it. But the notice has already gone out because we're talking about an application that will be filed in chamber. That's the thing. This is an application that will be filed in chamber. The question that I posed is, are we going to see another notification where the 14 days is going to run? Because the Gazette here, which I've been reading, clearly.
Can you also give us
what gazette and so forth. Now it become
The gazette, I don't have the article, but the Attorney General has it, which is the extraordinary gazette which is already before you, which is General Notice 938 of 2018. So the point is that at the time when this gazette was being published, it is the notice effective. So if it is the notice effective, what we are saying is that at the time of this publication, it makes reference to there being supporting document. That's that important. Doesn't matter that the application has been filed or has not been filed. It's for anyone who is interested to pick the document and then ascertain whether you want to oppose, you want to consent, you want to do whatever in chambers. So the question is that there's not going to be any other notice apart from this gazette already. That's the point we are making. So the supporting document, whether or not there's an application, they must be there according to this gazette we have published, unless the gazette was invalid for one reason or the other. That's the point we are making. So the fact of the matter is that the gazette itself, which is the notice, makes reference to support document.
In fact, Chair, what Mr. Machaya is saying, and the Attorney General is alluded to that the gazette is meant to avoid individual deposits of service. So once the gazette is there, it is assumed that every interested party has been given the notice. The minister at a particular time of his interest within 30 days is going to submit the application. But how then will the individual interested parties know that now the application has been deposited? This is where Mr. Machaya says, by virtue of the statement alluded to by the AG, that the gazette is an omnibus, not a notice, which then must then inform interested parties to collect paperwork. What the AG may want to advise us now is that how are the interested parties going to know that on the 21st of November you deposited the application?
Yeah. What we have done, because the office referred to is my office, and my subordinates have informed. I think so far only 2 people have come, as far as I know. I was away the whole of last week, but this morning I wasn't told any more had come. And they had been informed to come back Friday last week. And I notified them when I was out of the country that can they be advised to come back Friday this week when I am back. So it's only related to those who have come to uplift the information.
But for what? To come back for what?
To collect the application.
So now you admit that Attorney General, I think to make progress, can we have those documents tomorrow?
The application is not yet ready.
The supporting that compels you to make the decision. Can we have them tomorrow?
Yes, no problem.
Thank you.
But Chair, as a matter of principle, Chair, the Attorney General said the purpose of the gazette is to give an omnibus notice. Now he is saying I'm going to be following up on each individual party to give them advice as to when I collect the document. I mean,
I think what is important is I think it's good when we deliberate. Why don't we wait for the deliberations?
It's okay.
I have public questions with the Attorney General. I asked him if, in his view, because he keeps referring to this act, is this act a good law? Because you are the one who advises the minister, and by extension you are the one who advises our president. Is this good law, particularly considering that it was enacted in 2004 and it predates the current constitution, and it militates against the extended Bill of Rights in terms of the fact that it ousts the rights of shareholders, invariably it ousts the rights of workers themselves and places them on one man who is the administrator in this case. And also it elevates a single individual, the minister in this case, to the level of a whole court. For instance, we've been grappling with the question where does that leave the standing court decision on the scheme of arrangement? In your view, because with all due respect, Honorable Attorney General, I am now arriving at the decision that sometimes we will think that our ministers have problems, yet they are ill-advised by government lawyers. Is this a good law?
Why don't you wait that for the question that is it a good law or not?
Well, to begin with, I'm really not a policymaker, but in my view, the Act does not contravene the Constitution. That is the view I hold. So, whether or not it's good, it's a value judgment, but the whole purpose of it is to enable government to quickly follow after public funds. That was the whole purpose. And to that extent, as far as government is concerned, that is good law.
I don't understand and will never understand what will not make for bad law. If a piece of legislation takes away the rights of shareholders, if a piece of legislation takes away the rights of workers in an institution, well, that offends against the Constitution.
Well, the same happens when
Even if you are taking away a people's right for a minute, Attorney General, that offends against the Constitution.
I think the Attorney General responded. He says that he does not see where it controls. It's up to us as a legislature to now deliver it. Honorable Billa, I saw your hand was up. Honorable Billa.
Thank you, Machaya has been overtaken by events. I will try next time.
Okay, honorable members, we want to wind up this now. Yes, Honorable Choma, then Honorable Gebuza.
Thank you, Chair. In the Gazette, the AG, you appointed an administrator. Is there a process that you follow while you're appointing an administrator? If there's a process, can you just run that through by us?
I'm not sure I understand. The minister is the one who appoints. I merely act as the minister's draftsman. I don't inquire into who those individuals are or what their qualifications are. But out of interest, I may ask for that information. But it's really the prerogative of the minister. What I need to satisfy myself is if the provisions of the Act for the granting of an order of reconstruction been fulfilled by the information I've been given. And if I am satisfied, then I advise the minister to go ahead. If I'm not, then I'll tell the minister, you don't have enough information for that, and you cannot proceed to publish a reconstruction notice.
This thing is a lot of stakeholders. After publication, the Attorney General says 2 people came to inquire for the application with the other paper. And they were advised to come back on Friday. 2 out of the whole big number. Now those who did not come, how does he intend to advise them or to communicate to them about coming back on Friday? So the 2 were told to come back on Friday, but the others who did not come, what should they do? How do they know about the Friday date?
Yeah, I think it's a very pertinent question because you have not satisfied this committee in how all the stakeholders are going to be notified because already there are 2 have come. In one case, with a lot of shareholders, the public listed company is in the appreciate. And what efforts do you intend to undertake to ensure that all stakeholders are actually told?
Honorable Chairman, the notice in the Gazette is constructive notice to all interested parties to come and collect the information. They are not forced to do so. That's why the word may is used. They may not wish to oppose the reconstruction order.
I don't know if you hear yourself. Now you are admitting, yes, it's a notice to everyone to come and collect the information. But the information is not there.
Yes.
You just admitted to say
So what are they coming to collect? The notice. Now, you see, honorable members, I don't know if you're following.
Not back on Friday.
You come back on Friday, but you're saying the notice is for people to come and collect.
Yes. To
But
collect when it's
nothing to
ready.
collect.
To collect it when it's ready, Honorable Chair.
But it's supposed
Because,
to be ready.
no, because the Act gives 30 days for that application to be filed. And the section I just read, you section 8, makes it very clear that that supporting documentation relates to the application. It's very clear. It's put in,
Filed and access to information are two different things.
sorry?
Filing an application
Yes.
and access to information are two different things.
Yes, they're supposed to.
People who are also supposed to oppose that filing
Yes, they're
must have information and consult their lawyers or advocates. They might want an advocate from London.
Yes.
An advocate, how much time will they have? Because there are shareholders in London.
Yes.
Two of Wangi. So what notice? And this is the issue now. What have you done to notify foreign shareholders as well?
This notice is enough notice to them.
But you have no information.
Sorry?
There are no
No,
documents. They're only
that's why I'm
documents.
saying the information is attached to the application. That section 8 I read you in the Act says we must file the application together with all supporting
As soon as the
documentation.
notice is there, don't convince us now with the notice and application.
No.
We now know what an application is, and we now know what a notice is. The moment it is gazetted, that's a notice. People must have access. And then from that to 30 days, within the minister must appear before a judge so that it is confirmed. But before people appear before a judge, all stakeholders must have adequate information to prepare with their lawyers to then appear before a judge. And then the judge confirms yes or no. Is that not correct?
That is correct. What I'm saying is what you are saying.
But the information for them to take their lawyers to prepare is not there.
No, that information is contained in the application in terms of section 8 of the Act. The notice in the Gazette is a notice which we publish, which we try to paraphrase the provisions of the Act.
The Attorney General said only 2 people came to collect, as though only 2 people came to collect when there's information. But then, what more people came and there was nothing? I don't quite get. The Attorney General, you said only 2 people came to collect, as though those 2 people came to collect and there was something for them to collect. And you told them to come back on Friday. So what about the rest of the people? How, if they had come, they would have come to collect nothing. Have people come, their shareholders outside the country, as the Honorable Chair says, had they come, flown to Zimbabwe or sent somebody to collect, what would they have collected?
Yeah, they would have been told the information is not yet ready. Can you come back and collect it?
So, honorable members, the point to be made here is
what the judge was acting.
Yeah. Sorry, Chair.
It's a good point.
Sorry, Chair. I've got one.
Okay, after order of Matana,
Thank you.
Ndechokwadi kuti administration iso na minister kana issues kuti company iende mberi andizvo iendera mberi kubudirira saka nachikumbira kuti bvunze kuti administrator uyu kana semaitiro akaite kusvika achifaya munhu wese achimisa maoko acho mukuba zvinoenanga iri sendabvunza mubvunzo yokuti pangu kukweko zimasco yakaita coordinator pana then tikataura nayo tikachikumbira kuti judicial management iwe ikauya yauya hainambofa kana munhu wani yakasvika ikajoina nemamanagement anga ine experience iyo ikava neexperience yava vakasanganisa kambani ikabudira within 3 months inoziva I think you know that yakabva yabuda and zvikwereti zvo zvikabhadhira kambani yako mhanya zvakanaka isina pachikwereti wani kuvanhu and at the same time judicial management yakato yakakungwara saka administration iyi yakasiyana neoperation yani nejudicial kusvika ichifaya vanhu vese kudaro zvokuti indezvo vane experience nehwange chaicho hakuchina as far as vakaenda mberi kuti even administration ite bazi guru rakaunzana rasvorwa neworkers committee vasevenzi zvavo varishora kuti izvi hazisi ndizvo izvi hatisi kukwanisa kushanda navo handika zvokuti munofunga kuti ari ega achatanga kuimplaya vamwe vanhu simuona ndakaita workers committee nevasenzesa vachisapota kune munhu angasadzwa nemadirectors nemashareholder pamwe chete vagaradari ravo vakasarudza manager wavo vakati achita take over asi this manager akaitwa found neworkers committee same other companies abudiri workers committee they are very effective dzinokuziva kuti manager wayaiperforma uya angasaperforma uyaiperforma ndezvakashandiswa kuna manager akarecommend wari kufunga kuti as workers committee ndiye akubvara this stance yakatorwa
respond.
Judicial management ne-reconstruction order hazvina kumbosiyana mashandiro azvo. At the end of the day, you've got a process where a court confirms that one person should take over the powers of the shareholders, the creditors and the board to run the company to make it turn around. The only difference between the provisions, the Companies Act and the Reconstruction Act, the government gave itself preference where it owed money and enacted the Reconstruction Act. Otherwise, this process is just under the Companies Act, where the same process would follow. The court would appoint a judicial manager, and the judicial manager takes over from the management and from the board. And also the powers of the shareholders are suspended while the judicial manager is there.
Yes, thank you, Chair. Chair, it's a good follow. It now becomes a follow-up. In the 8th Parliament, we had a General Laws Amendment Act, which consequentially amended and aligned to the Constitution about 114 to 118 laws. Would you believe, seeing you continue to talk about the judicial manager, which might now, with the coming in of the Companies and Entities Act, might be a thing of the past? Now that we have an Insolvency Act, in particular way it relates to Schedule 100, I believe, would you think, in your view, there is need to align the Reconstruction Act with the Constitution in the current obtaining environment? Do you think, in your line of thinking, it is prudent to immediately and expeditiously align the Reconstruction Act,
I think the
all other
question
acts,
has been asked is it
with the Constitution?
and with all the terms used to align?
If you're aligning an act, you're aligning it so that it's consistent with the Constitution. And that presupposes that it's inconsistent in certain respects with the Constitution. It may be that it's not inconsistent, but perhaps the policy direction of the Act is no longer suitable. And that is for the policy makers to attend to.
What is your opinion?
Thank you, Chairman. I just wanted to say I think we've done justice to the Attorney General. We can continue to go round and round in circles.
Why don't you allow me to make that decision?
Okay, I'll make my comment.
I think you direct your question. I said you are the last one.
Thank you. That's my view. And I wanted to comment that I heard him saying he was reading what the Attorney General Act maybe put into place or whatever. And the Attorney General is saying there are days which are there, is not yet prepared. That is what I am hearing. And if you are not prepared, be prepared to give the people the right information. And those who are aggrieved, he has said so, that you still have 14 days, am I right, for you to also follow the law. So I think, in my view, it's in order.
I think the only thing in order is that you must make the papers available. The 14 days is to go to court. It's a process, but information must be available to all the stakeholders. And I think we've also asked for that information to be given to us. Attorney General, before you leave this Parliament, I want you to be conversant with the Constitution, so that I think you guide people accordingly. 139 of the Constitution
in terms of standing orders. It talks about the proceedings of the Senate and the National Assembly are regulated by rules dealing with standing orders. Rules dealing with standing orders. On the recommendations of the Committee of the Standing Rules and Orders. Are you there?
Yes, I am there, Honorable
So this
Chairman.
is the standing rules and orders. Who's called to come to Parliament? Because I can see that lack of information makes you give them the wrong information. So that talks to Standing Order Rules 25 of this book, which I'm sure as Attorney General you have. For the purposes of exercising and performing its functions, the Select Committee must have the power to summon any person to appear before it or give oral evidence or for affirmation. B. Summon any person except the President to appear before it or to produce any documents required by it. You misled the nation by saying that the administrator is not supposed to come. You were wrong, and he said as an Attorney General, you are supposed to also talk to this. This is what guides us. And I think because the headline of the Attorney General says administrator cannot come to Parliament. If Parliament regulated by this Constitution in terms of Standing Orders 139 and read together with Standing Orders 29, talks about anybody except the President. I think it is important that you're conversant with the Standing Order rules so that you advise people lawfully. Thank you.
Yes, Mr. Chairman, I disagree with you.